Good morning, all. This is the refresher course on interplay of GST with other laws, and today we are having Rohit Jain sir, one of the star batsmen in this GST IPL. IPL means interplay with other laws. तो ये इसका बहुत important session है, and as Rohit Sharma hits lots of run and on the favorite ground of Wankhede. So RERA and real estate favorite ground of Rohit Jain sir, and we will be enjoying his batting today. I welcome Manish Gadia sir, Regional Council member, Jayesh Thakar, coordinator for today's session, then Sumit Jhunjhunwala, Jinish Shah, coordinator, and Yashwant Kasar, our Regional Council member. I request Yashwant Kasar to please introduce the speaker. Over to you, Yashwant.
Thank you, Mesa. Friends, for this today's important topic on interplay of GST with other laws, we have a very learned speaker with us, Rohit Jain sir. Rohit Jain is a partner and heads the tax and customs practice at Economic Laws Practice, ELP, a tier 1 law firm in India. Rohit has been with ELP since its inception and has over 2 decades of experience in handling matters related to tax in both advisory and litigation matters. Rohit has advised various Fortune 500 companies and Indian conglomerates and has also been involved in making representations to the Ministry of Finance, the Ministry of Commerce in relation to various tax policy matters on behalf of numerous industry associations. He has been a part of select committees formed by Ministry of Finance and Ministry of Commerce on various tax and trade matters. Rohit has been ranked as an elite practitioner by Asia Law Profiles, has been ranked as a Brand 1 lawyer by Chambers Asia Pacific, recommended by Global Tax Directors Handbook, and has also featured in World Transfer Pricing Guide. He has also been recognized in the Benchmark Leading Lawyers Guide as the dispute resolution star for the tax, and has featured in the International Tax Review's Tax Controversy Leaders Guide and Indirect Tax Leaders Guide. He is regularly invited as a speaker, panelist, moderator at various international and domestic conferences. He is sought for his thoughts and perspective on India's tax and trade laws and has been a regular keynote speaker at American Conference Institute in San Francisco, as well as in several tax-related conferences across the world. As India member of TaxSign, Rohit hosts regular webinars and learning sessions on Indian tax laws, and he is often quoted and is regularly invited to author articles in prestigious international journals and leading domestic publications. So friends, for today's important topic, he is the most, I would say, the most apt person to talk about various laws related to sale of goods, general clauses, transfer of property act, RERA, and its interplay with the GST. So we are fortunate to have Rohit Jain sir here. I welcome Rohit Jain sir, and this is his brief introduction, and I hand over to Umesh bhai.
Yes, thank you, Yashwant sir. I request now Rohit Jain sir to start the session. Over to you, sir.
Good morning, and of course, at the outset, thank you WRC for inviting me and giving me one more opportunity to share some thoughts on this important topic, which is interplay between the GST and the other related laws. What I would request, I will of course now switch off the webcam because I don't want any network issues coming up. We will go through it, and if anything that you see that the slides are not moving or something is not happening, please immediately point out to me so that I will change if I need to change something. With this, again, once again, thank you for inviting me for this seminar. And let me just straight get into the topic today. And clearly, the topic has been identified WRC to talk about other laws. Now let's before we get to the interplay of GST with other laws, we just wanted to start with that. What we intend to cover today is the judicial perspective, then GST and other legislation such as TOPA, which is Transfer of Property Act, Sale of Goods Act, and General Clauses Act. And the third aspect is GST vis-a-vis the RERA. Let me start with the first one, which is the judicial perspective. When we talk about a judicial perspective and an interplay between GST law and other legislation, there have been significant development. Historically, there are a lot of judgments which have taken this looked at very differently. And one of the famous judgment of this aspect is the Honorable Supreme Court judgment. Case of this is how one should look at it when we talk about the interplay between various legislation and the tax law. And we have intentionally quoted this at para 7 of this particular judgment of Jaswant Singh Charan Singh. And most importantly now, if you look at it in this context, okay, so the issue which was before the Supreme Court that time, that how do we interpret in the context of tax laws, what do you mean by coal? Whether charcoal which is being produced from vegetable could be considered as coal or not. With this sort of a understanding, the Supreme Court was looking at this tax law with the other regulatory law applicable to the coal. And how the Supreme Court has dealt with this issue, this is very important for all of us to really read this para 7 of the Supreme Court judgment. And I'll read it quickly. It is a well-settled principle. In constructing a word in an act, caution is necessary in adopting a meaning ascribed to that word in other statute. So the first thing is that there has to be a cautious approach that one needs to take if I want to adopt the meaning of that word in the other statute. And this finding is absolutely, I love this, the observation of Lord Loreburn here, which says that it would be new terror in the construction of acts of parliament if you are required to limit a word to an unnatural sense, because in some act which is not incorporated or referred to such an interpretation is given to it for the purposes of that act alone. The strict sense in which such a word is to be found in another statute may mean that the etymological or scientific sense and would not in context of another statute be applicable. To which our attention was drawn to it, it would neither be possible nor safe to adopt the meaning of the word coal given in those provisions for the purpose of the act under construction, nor can we infer that there is a legislative policy consistently followed by the legislature merely because the word coal has been used and meaning a mineral product in the context of this statute. It would not therefore be possible to discard the meaning of that word coal in this statute as understood in the commercial and popular sense, and to adopt its connotation from other statutes passed for different purposes in context of different objects. So what does it really mean in a nutshell? That, and which is what I put it on the left side. In a construing a word in an act, caution is necessary, and it would be a new terror in the construction of acts of parliament if it was not required to limit a word. Yes, please.
Hello, Rohit sir. Sir, वापस show my screen करिए ना sir एक बार.
Sorry, show my screen, okay?
हाँ sir.
Is it open? Screen is coming.
2 मिनट सर. नेट आपका नेटवर्क स्लो है ना सर, इसलिए अभी तक आया नहीं है. हाँ सर, आ गया सर. हाँ सर, आ गया सर. रोहित सर आ गया सर.
Okay, thank you. So therefore, what does it mean? That till the word has been borrowed, till the reference has been made to other statute, you cannot straight away take a definition of other statute for interpreting the statute that you are really looking at it. So put it in a nutshell, if you are looking at the GST law and interpreting certain provisions of GST law, you cannot just refer the definition of that particular word or the term in terms of the other statute, because if you look at that way, then it is nothing but a terror in a constructing a statute. And you look at it, how what is the language that Honorable Supreme Court has used. Therefore, till it is not being referred by incorporation, you cannot just refer that to the other statute and try and borrow that. We were examining some time back that supplies to railways is liable to lower rate of GST. Now, what do you mean by railways? In a Indian Railways Act, it is defined, which is regulated by the Indian Railways, Ministry of Railways, and so on and so forth. But what is the general common parlance of railway is that what is run on the track, what is run on the rails is the railway. Now, if you look at it in that context, where it is available as a lower rate of benefit or not, you can't rely upon the definition of railways as defined under the Indian Railways Act. So to put it in a perspective, that whenever we are interpreting the provisions of GST law, it is important for us to really refer to those definitions what is provided under the GST law. It is impermissible for us to look at the definitions under the other statute and borrow that definition for interpreting the GST law only if it is being referred by way of an incorporation, then only we can refer to those definitions. So very important principle which has been settled way back in 1963 or 67 by Honorable Supreme Court in a famous judgment, what we call Jaswant Singh Charan Singh case. The second principle also, which is very important, which is what all of us need to be really looking at, is the common parlance test. That when we are interpreting something in relation to any statute, it is also settled law, and this is the important in terms of the tax law, is that the primary object is to raise revenue, and for which purpose they classify diverse products and articles and substances. Resource should be had not to the scientific or technical meaning of the terms or expression used, but to their popular meaning, that is to say the meaning attached to them by those dealing in them. And that is what we call it a common parlance test. So very important principle. Why am I dwelling on these issues today? Because when we talk about interplay between the Sale of Goods Act, interplay between Transfer of Property Act, interplay between the RERA Act, it is not necessary for us to straight borrow those definitions and apply for the purpose of GST law. So the first principle, you cannot take those definitions. The second principle, that you will have to look at it based on the common parlance test, and then only you apply that while interpreting the tax law. And the another principle similar to Jaswant Singh Charan Singh is that if reference to other legislations, then only it is allowed to be borrowed. And I will read again one more judgment of Jagat Ram Ahuja case, para 23, which says that we may state here itself that the words and expressions defined in one statute as judicially interpreted do not afford a guide to construction of the same words or expression in another statute, unless the both statutes are pari materia legislations, or it is specifically so provided in one statute to give the same meaning to the words as defined in other statutes. So very important concept again, that both the statutes should be of a pari materia, and at the same time it is effectively being provided that this is the term will be borrowed, incorporated as per defined in the other statute. So very important principles which have been laid out in our country by our Honorable Supreme Court for years now, that when we look at it, the interplay between the two legislations, it is impermissible for us to straight borrow the definition from other statute and look at it and apply in the GST law. With this backdrop, with this sort of opening aspects of how do we interpret the interplay between the two statutes, one of the again the fundamental principle is the contextual interpretation. What was the context in which these terms have been defined in, say for example, under RERA Act, and how these have now got defined under the GST law? One needs to still apply that in a contextual way and look at those provisions and then apply here. Now with this sort of principle, which is what we are bound to adhere to, these are the principles which have been set by the Honorable Supreme Court, we will have to go with this and look at it in that context. With this now, let's start examining the interplay between the Transfer of Property Act, Sale of Goods Act, and the General Clauses Act in the first part of the presentation. And then in the second part of the presentation, we will deal with the issues of RERA and the real estate. And in that context, how one should really look at it in the aspect of it. Now let's go to the first one. Comparative analysis of the definitions, which is in the context of goods and services. These two definitions we all know are very, very critical definition, because GST today is applicable only in the context of supply of goods or services. If there is no supply of goods or services, GST is not applicable. Nobody is required to even bother about complying with the provisions of GST law. So let's look at these two definitions first under the Sale of Goods Act. Now, Sale of Goods Act defines the term goods, means every kind of movable property other than actionable claim and money, and includes stock and shares, growing crops, grass, things attached to or forming part of the land, which are agreed to be severed before sale or under the contract of sale. Services, of course, it is not to be defined under the Sale of Goods Act. So what do you mean by goods when we talk about this is that it is a means every kind of movable property. So first it has to be a movable property, and we know we have series of disputes what is movable, what is immovable. So the first aspect is it has to be a movable property, and then the exclusion under the Sale of Goods Act is qua the actionable claims, money, but specific inclusion under the Sale of Goods Act is stock and shares. So the securities, the stocks for the purpose of Sale of Goods Act is effectively considered as goods. Now let's look at it. General Clauses Act 1897. The term goods and services have not been defined. Transfer of Property Act, again these terms have not been defined, because we know that these terms are applicable only the Transfer of Property Act, primary applicable for the context of immovable property, sale of a land, sale of a building. We are talking about the terms goods and services, so it's not defined under Transfer of Property Act. Now let's compare with the CGST Act here. And interesting, you will find the variance between what is being defined under the Sale of Goods Act and what is defined under the GST law. Now read the definition of goods under the Sale of GST law, and this is what we are really debating today. Goods means every kind of movable property other than money and securities, but includes actionable claim, growing crops, grass, and things attached to or forming part of the land, which are agreed to be severed before supply or under a contract of supply. Now let's compare with Sale of Goods Act and the CGST Act as a definition of goods. First of all, both are applicable for movable property. So far so good, no difficulty. For both the purpose of both the legislation, goods means what is considered to be every kind of a movable property. Now comes to the second aspect there, other than actionable claim. So Sale of Goods Act excludes the actionable claim, whereas goods definition under the CGST Act includes the actionable claim. Now you can start imagining the distinction between Sale of Goods Act and GST law, because GST law includes the actionable claim. And now when we include actionable claim, of course we have a Schedule 3 which excludes some of the activities in the nature of actionable claim. But in the start of it, where in terms of the goods definition, Sale of Goods Act does not apply to actionable claim, whereas its GST law definition of goods includes the actionable claim. And when it comes to securities and stock and shares, you will find that the Sale of Goods Act includes specifically stocks and shares being goods, whereas under the GST law, it excludes specifically other than money and securities from the definition of sale in the definition of GST law. Now you start looking at these two terminology as it is defined under both the legislations. You will find that there is a stark difference which has been made. Of course, the principle is that it is a movable property, but at the same time, something which is included specifically is excluded under the GST law. Something which is specifically excluded under the Sale of Goods Act getting included under the GST law, because the purpose is very clear. GST law does not want to tax sale of securities or sale of money or transfer of money from one person to another person, whereas for the purpose of Sale of Goods Act, they want to administer and apply all the provisions of Sale of Goods Act even to the sale of shares or securities. This is the difference. Therefore, we cannot just straight borrow the definition of goods here and apply what is provided under the Sale of Goods Act. Look at the definition of services now. These are all not defined under any of this legislation. And we find the definition of service under the GST law means services means anything other than goods, money, and securities, but includes activities relating to use of money or its conversion by cash or by any other mode from one form of currency or denomination to another form of currency or denomination for which a separate consideration is charged. Now, please start examining this sort of a definition of service. I'm sure all of us are interpreting this for years now. At least now 3 years we are in GST and we are interpreting these terms. Services is clearly therefore a much wider in its scope. Services mean anything other than goods effectively is a service transaction, other than money and securities. Now, money and securities here is also excluded from the definition of service. But interestingly, the conversion of itself from one to other. So dollar is converted into rupees, rupees to dollars, dollars to euros, euros to dollars. All of this conversion is considered specifically as a transaction in service and maybe not been considered as Sale of Goods Act may as a goods transaction. Now, this sort of an expansive definition of a service now brings under the net even the immovable properties. And what is not an immovable property or what is an immovable property under the Transfer of Property Act, under the General Clauses Act, for the purpose of GST law, even the immovable properties, leave aside Schedule 3, we will deal with that, also includes an immovable property. That means any transaction other than movable property is deemed to be considered as a service as far as this definition is concerned. And when it comes to a real estate, for years now we are deliberating, debating that whether the development rights is an immovable property, whether it will fall in the definition of service or not. And all of these issues will come up. And therefore, start now comparative analysis of Sale of Goods Act compared with the CGST Act. You will find there have been, of course, differences in the definitions. And one cannot just borrow one definition with the other definition and apply in that context. And look at the principle that has been already set by Honorable Supreme Court, therefore, in this context. Moving on to the next slide. Now comes to immovable property. Now, as a term, immovable property is not defined under the GST law. And why is not defined? Because as far as legislature believe that goods means movable, services means anything other than goods. So they intend to cover transactions qua immovable property, except which are not covered in Schedule 3 as a transaction of supply of service being liable to GST. So they have not specifically defined the term immovable property. But this term has got defined under the RERA Act, under the General Clauses Act, and a Transfer of Property Act in an inclusive manner, or in fact, non-inclusive manner in that sense. So what is the way it has been defined under the RERA Act? Immovable property includes land, buildings, rights of ways, lights, or any other benefit arising out of land and things attached to the earth or permanently fastened to anything which is attached to the earth. Now look at it, this term under the RERA Act. That RERA Act is not only applicable to the land and a building, it also applicable to the benefits arising out of that land is also considered as immovable property for the purpose of RERA Act. General Clauses Act also defines immovable property shall include land, benefits to arise out of land, and things attached to the earth permanently fastened to anything attached to the earth. Again, the term includes not only land, but also includes benefit arising out of land, also being an immovable property. And then we have a Transfer of Property Act. Again, it is so widely defined, does not include standing timber growing. So everything else is considered to be immovable property, which is effectively the last part there, attached to what is to be embedded or for the permanent beneficial enjoyment of that to which is it is attached. And CGST Act has no definition of immovable property. Now, why is immovable property definition is relevant? Because of two reasons. One is for the purpose of definition of words contract, but more importantly, that the service definition is so widely covered, which says that anything other than movable property is also a service. And with that logic, what is typically considered for the purpose of RERA Act being an immovable property, what is typically being considered for the purpose of general law being an immovable property, what is considered for Transfer of Property Act as an immovable property may also get covered being an immovable property, but may get covered under the definition of services for the purpose of GST Act. And we will need to be examining whether this should constitute supply of goods or services. Very important interplay now. You start imagining in all of your minds that the things have been slightly different. In some cases, very largely starkly different. In some cases, it is slightly different. Where we need to start managing this definition in such a manner that it will give the right perspective in the context of tax law. Because ultimately, what we are interpreting, what we are advising to all our clients is in the context of the tax law itself. Now, with this comparison, let's therefore examine some of the judicial precedents on this topic. First, the development rights being a benefit arising from the land effectively must be held to be an immovable property. We have the judgment in the context of Cheda housing, but that may be right in the context of Sale of Goods Act, may be right in the context of RERA Act, may be right in the context of Transfer of Property Act. But even if it is an immovable property, it may be considered as liable to tax being a supply of service for the purpose of GST law. Second, development rights being a benefit arising from the land must be held to be an immovable property. Doesn't matter that is considered as liable to effectively GST in that context. And the last one is explaining the intricacies of the TD transaction. The tribunal emphasis on the aspect that TD constitutes an immovable property and is therefore not exigible to had a judgment for the service tax in the context of commercial projects, such as Chandigarh. Today under the GST law, and the way the terms have been defined under the GST law will have to administer in that context and has to be looked at it in context. This is very important that we all need to be careful about that what is defined in a legislation does not necessarily mean should apply in the exact same in GST law when we're actually looking at the GST law and principles and applicability of the GST for a particular transaction. Now, we also identified some of other transactions when we look at it interplay between these terms here. Actionable claim defined under GST law under other statute. Price or consideration defined under the GST law, also defined under the Sale of Goods Act. Buyer or recipient defined under 293, defined under the other statute, Sale of Goods Act. Seller also defined under the Sale of Goods Act. Movable property, immovable property, sale, lease, exchange, none of these terms are defined under the GST law, but these terms have been defined under the other legislation, whether it is the Transfer of Property Act or General Clauses Act or the Sale of Goods Act. Now, what is the relevance of this comparison here? The relevance of this comparison here is the terms which are not defined here, can we straight borrow that definition from the other statute? Answer may be no. The first principle is that you have to apply the common parlance test. You have to apply what is the popular meaning of this term, and then only you are allowed to borrow that from the other statute and look at it in that text. This sort of a definition which are not defined here, you'll have to first apply that principle. Let's examine, interestingly, the first 4 items in this list, where the terms have been defined under both the legislation and how there is an interplay between the both legislations when we look at actionable claim, when we look at it price, when we look at it buyer, when we look at seller and supplier. The price. What is sale of goods size definition means? Price means the money consideration for sale of goods. It is like a 1.5 line, not even a 1.5 line. If we put it in the entire one line, it is a one-liner definition. What is price? And look at it, our definition in consideration under the GST law. If one needs to really look at it in that context, it will be very difficult to come out of any transaction between the two parties not being considered as a consideration. Now let's look at some of the aspects here, right? Consideration in relation to the supply of goods or services for both includes any payment made to be made whether in money or otherwise. So first differentiation, that it is not necessarily money, it can be in other than money, it is a non-monetary consideration. In respect of, in response to, or for the inducement of the supply of goods or services or both, whether by the recipient or by any person, but shall not include. So look at it, these very important concepts under the GST law. Whether that consideration is by the recipient or by any other person, but shall not include any subsidy given by the central or state government. B, the monetary value of an act or forbearance in respect of, in response to, or for the inducement of supply of goods or services, whether by recipient or by any other person, but shall not include any subsidy, and provided that a deposit given in respect of supply of goods shall not be considered as payment made for such supply unless the supplier applies such deposit as a consideration for the said supply. Now please examine in this context, can the transaction you are supplying goods or services and your customer is paying something or not paying something, or you are getting indirectly some benefit directly from your customer or a recipient or by any third person, will it fall into the term consideration? And what in the context of sale of goods, what is considered is a price means the money
Rohit sir,
consideration, whereas when it comes,
Rohit
yes,
sir,
please. Yeah.
sorry to stop you in between.
Bolo.
Your slide is on TDR currently, development right, that Cheda housing and all that, and I think you are on consideration. So have you moved your slide ahead or something
Second,
like
I
that?
will. I have moved, but I think I need to stop and again reshare. Looks like 1 second, please.
Yeah, because we are able to see your TDR slide only as of now.
Now just see this, please.
No, yeah, it's gone completely. Mishra ji.
No, it will come. It will come. It will come. 1 second.
दिया वापस से दिया सर. सर वापस से शो माय स्क्रीन करिए सर.
Okay, 1 second.
सर आपके यहाँ पे नेटवर्क बहुत स्लो है सर.
Network. I thought change. Can you do me a second, please? I will just change the network.
यस सर, आप कर लीजिए सर, और मिश्रा जी थोड़ा वॉच रखो, हेल्प करो सर को।
Sir, okay.
हाँ आ गया सर, रोहित सर स्लाइड आ गई। मिश्रा जी
बोलिए बोलिए सर। हाँ सर बोलिए ना, सुन रहा हूँ। उमेश सर।
हाँ, रोहित सर से कोऑर्डिनेट, स्लाइड तो दिख रही है।
हाँ स्लाइड दिख रहा है, दिखे ना। उनके यहाँ नेटवर्क बहुत स्लो है, तो रुक जाओ, मैं पोस्टपोन करता हूँ सर। उमेश सर वापस ज्वाइन कर रहे हैं सर।
ओके,
Hello, Mishra ji, can you hear me?
यस सर, आपकी आवाज आ रही है रोहित सर।
Thank you. तो मैं प्रेजेंटेशन अपलोड करता हूँ, सॉरी फॉर ऑल ऑफ दिस।
इट्स ओके, प्लीज।
या
से प्रेजेंटर शेयर करिए सर, रोहित सर।
आ गया सर, आ गया आ गया।
आ गया ना प्रेजेंटेशन?
हाँ आपकी स्क्रीन आ गई, उसको स्लाइड शो कर दो सर आप।
बराबर है
जी,
ठीक है। We are on consideration clause now.
यस।
Okay, thank you very much and sorry for this again. So the term that I was reading earlier was in the context of GST law, where the term has been defined so widely as a consideration as opposed to the other legislation. Other legislation like Sale of Goods Act only has the term means the money consideration for sale of goods. Now, if you look at it in that context, nothing can be considered to be outside in terms of the consideration term as long as the underlying transaction is a supply of goods or services. Because the consideration has been so widely defined, whether it is directly, indirectly, in response to inducement of supply of goods or services, everything will get covered under the term consideration here. Now, moving on to the next slide. Okay, the similar concept that we had is the buyer or recipient. Now, look at it under the Sale of Goods Act. What is buyer? Buyer means a person who buys or agrees to buy the goods. Very simple term, again a one-liner definition. But look at it under the GST law, the term recipient of supply of goods or services or both means where consideration is payable for the supply of goods or services or both, the person who is liable to pay that consideration. So very differently worded definitions. When we look at it, Sale of Goods Act, the buyer would mean the person who buys the goods. That means the person to whom the title is getting passed. Whereas when it comes to a GST law, the recipient of supply of goods or services or both means where consideration is payable for the supply of goods or services or both, the person who is liable to pay that consideration. Where no consideration is payable, the person whom the goods are delivered, or where no consideration is payable for the supply of service, the person to whom the services is rendered. Now, if you look at it in that context, again, there has been huge distinction between who will be considered as recipient of supply of goods or services vis-a-vis who will be considered as a buyer for the purpose of Sale of Goods Act. Similarly, in the context of CGST Act, the term seller and the definition is supplier in relation to any goods or services, the person supplying the goods or services.
Rohit sir.
And shall in Haji,
Rohit
sorry.
sir, sorry, again the same problem. Actually, your slides are being seen. Currently, it is under consideration slide only.
Unlock.
Slide number 13.
Slide यहाँ से
And
move
sir,
क्यों नहीं हो रही है slide?
And sir, yeah, actually, it's not on the slideshow. So if you can do the slideshow and then see, sir. Yeah, now we are on the slideshow and now we are on the buyer recipient thing.
तो
Good,
मुझे
sir.
वापस वो stop sharing करके screen करना पड़ रहा है, but अभी ठीक है, अभी is it okay?
हाँ, अभी it's okay. सर एक बार एक slide आगे move करके देखिए सर, तो हमको पता चलेगा it is moving or not. Yeah, now sir. So now it's moving. We are on actionable claim. Yeah, good sir. Great. Continue, sir.
Okay.
Sorry.
Okay, sorry again. I don't know why there is this going back and forth, but anyway, at least now we are on a buyer and recipient slide.
Perfect, perfect, sir.
Okay, sorry, thank you. Okay, so the supplier definition under the GST Act is supplier in relation to any goods or services both shall mean to the person supplying the said goods or services or both and shall include an agent acting such on behalf of such supplier in relation to goods or services. Whereas a seller under the Sale of Goods Act is the sellers means a person who sells or agrees to sell the goods. That means again in the context of supplier, you would find that there have been expansion in the GST law that it also includes the agent of the supplier also as part of the particular transaction and liable to GST, as opposed to for the purpose of Sale of Goods Act. We all know the concept is that only the seller who has a right against buyer, or buyer can only sue the seller for any violation of the contractual terms. Whereas under the GST law, even the agents of a seller have been considered as a supplier and then potentially could be considered as liable to pay GST in that context. Now comes to the next slide, which is an actionable claim. We have seen the definition of goods. Goods for the purpose of GST law includes actionable claim but goods for the purpose of sale of goods act excludes the actionable claim. Now, why it is important to determine actionable claim, and this is very interesting now, and this is where we will start actually interplay between the two legislation. Now, if you see the definition of actionable claim under the GST law, it says actionable claim shall have the same meaning as assigned to it in section 3 of the Transfer of Property Act. Now, with this sort of a definition under the GST law, we are bound now to refer the definition of Transfer of Property Act of an actionable claim. And that is where the things will start now changing, because actionable claim now is being borrowed a definition under the GST law as per the Transfer of Property Act. And as per the Transfer of Property Act, actionable claim means a claim to any debt other than a debt secured by mortgage of an immovable property or by hypothecation or a pledge of a movable property or to any beneficial interest in a movable property not in a possession either actual or not. So effectively, now for the purpose of GST law, the actionable claim definition under the Transfer of Property Act plays a very important role. And we all know that actionable claim under the Transfer of Property Act has been examined by various judicial proceedings. Now let me take a simple example, a transfer of a secured debt. So I have a secured debt, and nowadays, given what the banks are going through, what is the shortfall of a cash in the market, one lender is transferring the secured debt from that person at a discounted price to other person. How will one read it that? Is it an actionable claim? Read the definition of actionable claims. Means a claim to any debt other than debt secured by mortgage of an immovable property or by hypothecation or pledge of a movable property. So it is a debt, but other than secured by mortgage of an immovable property. So all what we are talking about a secured debt or a hypothetic debt by a movable property, which is all our term loan, CC, all of these, except an unsecured loan. All of these are not considered as actionable claim for the purpose of Transfer of Property Act, will therefore not be considered as actionable claim for the purpose of GST law. And in terms of section 3, schedule 3 also, it is not excluded. Then where is the exclusion? When somebody transfers the secured debt from one lender to the other lender or other buyer. And that exclusion, when we look at it, a FAQ, they are trying to put that exclusion in the form of securities, where securities includes the derivatives, and what the GST Council has clarified through a FAQ, that it is considered as the derivatives. While that is still a big interpretational issue, whether this can be considered as derivative or not. But look at it now, that what is actionable claim needs to be borrowed it from Transfer of Property Act. What is included in the definition of goods includes the actionable claim. But in a service definition, anything other than goods gets covered. And if you now read harmoniously all these definitions, you will find that the secured debt, when I getting transferred from one person to other person, may not be covered in the definition of actionable claim, and therefore may be exposed to GST short of any other exclusions such as securities, which will be applicable. So again, now start looking at how the interplay happens between the various definitions in this context. Now look at it, the other definitions: lease, exchange, gift. All of these are terms which are defined and not defined under the GST law, but have been defined under the respective act, and which also has a certain relevance when it comes to a GST law. Movable property, the term sale, all of this we have examined, and now we compare therefore an interplay with GST with all of these other laws. It makes it very, very clear that GST law could be having a wider scope, or GST may have a restricted applicability. So let's put out some of the examples of here. Like GST law has a wider scope. Scope of services is extremely exhaustive, so that will cover everything under the GST law is get covered, which is not goods, is a service. B, Supply also include transaction of barter, exchange, and non-monetary consideration. Whereas we have seen under the Sale of Goods Act, it typically does not cover the transactions of this nature. C. Exclusion for all kind of actionable claim under the Schedule 3, except for lottery, betting, and gambling. So actionable claim in the goods is not excluded. Schedule 3 excludes actionable claim but not excludes lottery, betting, gambling. So again the wider in scope in that context. And the term consideration, as we have seen, also includes all sort of transactions which is directly, indirectly to be made, non-monetary interest also, which is charged beyond for the delayed payment of the charge. So in that sense, GST is much wider in scope as compared to the other legislation, and we need to keep that in mind. At the same time, if you look at it, GST has a restricted applicability. So the first one, transaction in security excluded, whereas under the Sale of Goods Act, goods include the transaction in securities, whereas under the GST law, it is specifically excluded. Now, let's look at the B concept here. Very interestingly, GST is applicable only if supply is in the course of business. Now we know a Sale of Goods Act, which is not in the course of the business or directly, it does not matter. As an individual, I am selling my laptop, I am selling my old car. For the purpose of Sale of Goods Act, all of those provisions are applicable because I am a seller, the person is buyer. Whereas for the purpose of GST, I have not sold that in the course of business, it may not be therefore applicable, and therefore GST has the restricted applicability in the context of these terminologies and the provisions there. Look at it, the C aspect here. GST is not applicable on petroleum products and liquor. So under the Sale of Goods Act, that is considered as a sale of goods, it is a goods, but GST is not applicable because it is excluded from the definition. And the D, there are exemptions provided for electricity, interest, and so on and so forth, which is effectively electricity is goods for the Sale of Goods Act. It is utility also. Interest is a service also, but not definitely liable to GST because exemption. So if you look at it in this sort of a perspective and start mapping the interplay between the two legislation, GST has a wider scope, whereas in some cases GST has a restricted scope. And therefore in that context, it is not necessary that one can straight borrow and apply the other concepts when it comes to the interpretations of the GST law. Now comes to the most important topic that we all wanted to look at it and deal with, is the GST and other legislation, primarily the RERA Act, read with the GST law. And when I talk about RERA, and day before yesterday I actually got a nice joke because the situations that we are all facing through because of pandemic and corona, that what is the difference between a bad mood of husband and a bad mood of wife? So bad mood of husband is actually a simple viral because it only affects him and he only has to go through that pain. But when it comes to bad mood of wife, it is actually like a corona. It not only affects to that wife, it affects to the entire family, in terms of it affects to the entire society. And that is how exactly what applies in this context here, that there has been such a significant interplay. It is like a bad mood of wife, where everything under the GST law, when it comes to a real estate sector, has now been borrowed it from the RERA definitions, and lot of dependency has been now provided and conceptually been taken it from what has been
Mishra ji?
defined under the RERA. Yeah. Yeah. Hello, Mishra ji, can you hear me, right?
Sir?
Okay. You can hear me, na,
Boliye, sir.
Mishra ji?
Yes, yes, sir. Yes, sir.
Okay, okay. So this is very important, and this is where now we all need to start looking at it when it comes to the RERA and the other GST provisions and how they have effectively been borrowed in terms of the interplay between these two particular legislation. Now let's start dwelling into this interplay between these legislation. Now the first thing first, okay, this evaluation of levy per se. And we have a K. Raheja Corporation, Honorable Supreme Court has held that agreements entered between the developer and a prospective purchaser is a worse contract. Then we have a Larsen and Turbo Limited versus State of Karnataka, again Honorable Supreme Court judgment, which has been held that this is a worse contract. Builder Association of Navi Mumbai, Bombay High Court held that it is nothing but a long-term lease premium towards supply is subject to GST. Now, if you look at it, all of these evolution of levy, RERA treats sale of a flat, sale of an apartment as an immovable property, whereas GST law treat this as a supply of service. So why we have put this across? Because we have a history now since 2008, the dispute started, then it has gone to 6, and then 2010, the finality of the judgment has come, and thereafter it is going on and on since then. In this context, if you look at it, the fundamental difference that I see is RERA treats sale of an apartment is nothing but a sale of a building, and sale of a building is nothing but an exclusion under Schedule 3. And therefore, RERA is premised on the basis that it is a sale of an apartment being an immovable property, whereas GST law treat this at the outset, it is a sale of supply of a service. And that is the very fundamental difference that we have between the RERA provisions and in the GST law. And that is where go back to my basic principle as laid down by the Supreme Court, is that you'll have to look at it in the context that what it has been effectively used for. And for the purpose of GST, we are looking at the taxing statute where they want to tax the transaction, whereas for the purpose of RERA, they wanted to give and regulate the entire sale of an immovable property and provide the security to the buyer and get the developer into more regulated environment. And while they are both two different legislation with a different objective, one treats this as an immovable property, one treats this as a supply of service. Ideally, immovable property should not be liable to tax, but because of the way the evaluation of levy happens in the context of these judgments, GST law treats this as a supply of service. Same thing for home solutions. Again, we have a Delhi High Court judgment which treats this as a supply of service while renting of an immovable property. So the first basic fundamental difference according to us is that there is been distinction in both the things, but at the same time, lot of things have got copied from each other and lot of definitions have been borrowed from the RERA definitions. Now, therefore, let's examine in that context. First, we all know the most relevant notification in the today's day and age for the real estate sector is the notification number 3 of 2019, which is dated 29th March 2019. Residential real estate project shall means a REP in which the carpet area of the commercial apartment is not more than 15% of a total carpet area of all apartments in an REP. Now start please examining these definitions. So shall means REP in which the carpet area of the commercial apartment is not more than 15% of the total carpet area. Please examine now. What do you mean by project? That project definition will have to go back to the RERA definition now. Look at it, the landowner promoter definition. A promoter who transfers the land or development rights or FSI to a developer promoter for construction of apartments and receives the constructed apartments against such transferred rights and sells such apartment to his buyer independently. You don't have a definition of landowner promoter under the RERA, but under the notification for the purpose of GST, we have got this definition as landowner promoter. Now let's look at it some other relevant concept. Like Schedule 3, we know Schedule 2. First, what is construction of complex pre-OC or sale, of course, is considered as supply of service. Sale of a land subject to clause B is considered as not liable to supply of goods or services. This is all we have been examining, we all know. Affordable residential apartment, a residential apartment in a project which commences on or after 1st April or an ongoing project in respect of promotion as exercise option in the prescribed form of central tax. Why are we bringing it all of this? Because all of these terms which are defined under the GST law have some correlation under the definition under the RERA, which are the definitions, right? Read this. A residential apartment in a project. What do you mean by project? As per the RERA Act, which commences on or after 1st April 2019, in respect of which the promoter has not exercised an option. What do you mean by promoter? As per the RERA Act, in the prescribed form to pay central tax on the construction of apartment serial number 3, as the case may be, having carpet area not exceeding 60 square meter. What do you mean by carpet area? As per the RERA Act, not exceeding 60 square meters in a metropolitan cities or 19 square meters and so on and so forth. So even a one definition that you look at it, whether it's a residential apartment affordable purposes or whether it's a project definition for the purpose of determining applicability, all of these terms have now been defined, what is defined as per the RERA Act. Now again we have a TDR provisions. Now, TDR, again, a very important one. There is an exemption for TDR. So that, of course, what we have debated already, that in the context of GST law, this is considered as supply of service, maybe an immobile property. But look at it in this context, that services by way of a transfer of development rights, FSI. What is FSI? Again, as per the definition of RERA, for construction of residential apartments by a promoter in a project. Very important term again, a promoter or in a project intended for sale to a buyer. This term has been defined and used at so many places, intended for sale to a buyer. Again, we have to, somebody was arguing with us at some point in time that intended for sale to a buyer, and buyer in this context as per the sale of goods act is only who is buying the goods, and therefore this term is not really applicable, because when I am handing over the flats or to my society members, can we consider this as a buyer or not? Now all of these definitions have been very important in this context, and we will deal with that. And keep that in mind, the intended for sale to a buyer, wholly or partly consideration received, except where the entire consideration has been received after the issuance of completion certificate. What is completion certificate? Again, the term defined as per the RERA Act. So we have all of these conceptually, we need to look at it. Or first occupation, whichever is earlier, and all of this. So lot of correlation now under the GST law with respect to the provisions under the RERA Act. So we all know that in case of a TDR, the GST is applicable under RCM basis by a promoter. Now who is the promoter? Again, as per the RERA Act. So why we are trying to make this sort of a provisions are that there are various definitions which have been borrowed from the RERA Act, which are very important when we determine the applicability of GST. The definitions are real estate project, the apartment, promoter, real estate regulatory authority, and a carpet area. All of these definitions have been actually borrowed from a RERA Act, and all of this definition has a far more impact, a significant impact when we look at it from the GST law perspective, and let's examine all of this and how this really interplay between the RERA and GST law exists. So real estate project as per the RERA Act, apartment as per the RERA Act, promoter as per the RERA Act, real estate regulatory authority as per the RERA Act, carpet area again as per the RERA Act. And therefore, there is very important that we need to look at it in this context and examine the applicability of GST. Now we have the definition which are under GST, not borrowed a definition from RERA, but which are similar to GST law. So commencement certificate, not a definition as borrowed it as is from RERA. And this is very important. We will tell you this, why this is important. But commencement certificate is a defined term under the GST law, also defined term under the RERA, and slightly there is a difference in that. Development work, defined under GST, defined under RERA, competent authority, external development work and internal development work. These are some definitions which are same as per the GST law and the RERA, but they are not been copied or borrowed it from the RERA, unlike the earlier slide where promoter means what is defined under the RERA Act. So there is a difference between these two sort of concepts that we need to really keep it in mind. Now let's look at it. Some of the definitions which is defined under the GST law but not defined under the RERA Act. The first one is residential apartment is only defined under the GST law and not under the RERA Act. And why this is important? Because GST law treats and gives the different treatment for sale of a residential apartment and sale of a commercial apartment. Sale of a residential apartment is liable to 1% and 5% or whatnot now in the current scheme of things, whereas sale of a commercial apartment continues to liable at 12%. So GST law makes a distinction between the residential apartment and a commercial apartment, whereas the RERA Act treats everything as an apartment and therefore is applicable irrespective of whether you are selling a RERA, a residential apartment or a commercial apartment. So that again makes a distinction between the RERA provisions and the GST law here. Now let's look at it, some RERA important definition as we have just discussed. RERA defines the term apartments, means whether called block, chamber, dwelling unit, flat, office, showroom, shop, godown, premises, suite, tenement, unit, or by any other name, means a separate and self-contained part of any movable property, including one or more rooms or enclosed spaces located in one or more floors or any part thereof in a building or on a plot of a land used or intended to be used for any residential or commercial purpose or residence, office, shop, or carrying on any business, trade, profession, or whatever. So look at it, the definition of apartment is such a wider in terms of this that anything that you called, whether it's a chamber, whether it's a dwelling unit, whether it's a tenement, whether it's a separate or self-contained immobile property, including one or more rooms or enclosed spaces, everything under the RERA is considered to be an apartment. So very, very wider term in that context, because we have seen multiple cases where client will approach us, oh, I am effectively making a hostel. Will it be considered as apartment which I am required to pay GST? Why not? Look at it, the term here, any premises, whatever you call tenement unit or any other name is a apartment. You are effectively required to pay GST irrespective whether you call it a hostel or whether you call it a boarding school or whatnot. Similarly, look at it, the term real estate projects. Real estate project means the development of a building or a building consisting of apartments or converting an existing building or a part thereof into apartments. Very, very important. What is a real estate project as per the RERA is, and this is the borrowed definition. Mind you, under the GST law, these are the borrowed definitions for the purpose of GST also. So real estate project means development of a building or a building consisting of apartments or converting an existing building or a part thereof into apartments, or the development of land into plots as the case may be, for the purpose of selling all or some of the said apartments or plots or a building as the case may be, and includes the common areas, the developmental work, improvements and structures. All of this is now been considered as real estate project for the purpose of RERA, and in turn it is considered for the purpose of GST law also as a real estate project. Some of the interesting concept now: occupation certificate and a completion certificate. Now these terms have been defined separately under the RERA law. They have been defined very distinctly. Occupancy certificate under the RERA defines occupation certificate means the occupancy certificate or a such other certificate by whatever name called, issued by the competent authority, permitting occupation of any building as provided under local laws which has provision for civic infrastructure such as water, sanitation and electricity. And a completion certificate is the completion certificate or such other certificate name issued by competent authority certifying that real estate project has been developed according to the sanctioned plan, layout plan and specification as approved by the competent authority under the local laws. So now examine in this context that these are the two separate terms under the RERA. One, what is called occupancy certificate, and what is called completion certificate. So occupancy certificate permits the occupation. Completion certificates actually gives the completion as per the plan which was approved by the competent authority. These are the two separate terms. But when it comes to a GST law, it has been used so loosely. Somewhere the term used is the completion certificate. Somewhere it has been interpreted to mean an occupancy certificate. And we all know in day-to-day life that we are only talking about OC received, OC received. OC is the occupancy certificate, whereas the completion certificate. So if you look at it under Schedule 3, what is, now I'll go back to Schedule 3. The language used in Schedule 3 for the purpose of GST is, look at this, 5B, construction of a complex building civil structure, including a complex building intended for sale to a buyer wholly or partly, except where the entire consideration has been received after issuance of completion certificate, where required by the competent authority, or after its first occupation, whichever is earlier. So the term used here, after issuance of a completion certificate, whereas we are trying to interpret completion certificate here means a occupation certificate, and trying to go on the basis that once a OC is received, I am effectively not liable to pay GST. If OC is not received, I am required to pay GST. And rightly so, no difficulty at all. That is how the industry understands this. OC also, if you go on the second part of the definition here, or if you see, or except where the entire consideration has been received after issuance of completion certificate, wherever required by the competent authority, or after its first occupation. So typically, once you receive an OC, that is, the authorities are permitting to you to occupy the premises, you effectively get the OC and give the occupation to somebody, and you will still not be required to pay GST, because it is the beyond the first occupation in that building. And once it is beyond the first occupation and you are receiving the consideration after that occupation, you are still not liable to GST. So therefore, no difficulty at all. even though the terms have been distinctly defined under the GST law, one is an occupation certificate, one has a completion certificate, doesn't matter. We can safely go on the basis of OC being received. And if you receive an OC, we will be able to take a position that there will be no GST payable, because you will give the first occupation to the person, and that will be a consideration received for fresh sale of a flats. Beyond the first occupation will definitely not required to pay GST. And in that context, we already have a clarifications issued for the occupation certificate, which says the occupancy certificate is a legal requirement and would act like a completion certificate. Hence, the date of such occupancy certificate would be deemed to be the date of completion. And we also have a judgment of AR in Bindu Ventures Limited, which was held that this is effectively being treated at par, and you don't need to really worry about in that context. Why I'm trying to bring the distinction between the RERA Act, that RERA has these two terms separately defined, where for the purpose of GST, these are used interchangeably, and we can go on the basis of whatever is the applicable. Now, therefore, let's come to some of the important conclusions as far as the RERA and the provisions there involved in that sort of a scenario. First, there is a significant interplay between RERA and GST. The terms which are promoter, terms which are project, the terms which are defined as carpet area, because carpet area, how do I calculate carpet area is what you have actually defined to particularly RERA purposes as a carpet area. Because if your carpet area is below 60 square meter and your price is below 45 lakhs, you can get a position that this is affordable housing. Therefore, don't ever dispute that how these terms needs to be looked at it. Look at it, what you have been defining under the RERA purposes, what is the carpet area defined, what is the project that you have defined for the purpose of RERA, and then you calculate all your tax position under the GST, whether this is a residential project or a real estate project. Second, whether the carpet area is below 60 square meter or above 60 square meter. Third, there are a lot of issues in terms of the rate of tax, whether I am required to pay ongoing project or a new project. Of course, that an historic issue as of 1st April 2019 onwards. But I'll give you simple example there also. As a promoter, when you actually file the details in the context of GST, at that point in time you needed to give the percentage completion. Now you submit something to RERA, and for the purpose of GST, because RERA includes the land cost also, for the purpose of GST it does not include land, it is effectively only construction cost. So you'll have to make some distinction in that context as well to calculate the percentage completion for the purpose of ITC reversal. So important aspect again, that project, carpet area, your real estate project, whether it's a residential real estate projects, all of these terms, promoter, to determine the reverse charge liability of GST is very important terms as borrowed it from the RERA definition will have to be applied, and therefore there is a significant interplay between RERA and GST. Second, alignment with RERA has streamlined lot of interpretational ambiguities. Now, why this was necessary? Because I just said that there have been lot of interpretational issues which have been raised initially, that whether RERA I declared something, but for the purpose of tax law can I treat it separately? So let me give you a simple example, that I have a project, and in a project I am actually constructing a 5 residential towers, and in a 5 residential towers which I am constructing, for the purpose of RERA, I can register first 3 towers as one project and second 2 towers as a second project. So RERA allows you to define each floor also as a different project, or 3 buildings as a different project, whereas for the purpose of commercial understanding, it is one contiguous land, it is one entire project. Now, how will I decide what is a project for the purpose of GST now? If this definition would not have been exist, where the project is not borrowed from RERA, then we would have had a hell lot of confusion. That how do I calculate a project? Should I take it the entire 5 buildings, or should I take it only 3 buildings and 2 buildings? What do I really do? But now they have made it very clear that whatever you define as a project for the purpose of RERA, the same principle we will apply even for the purpose of GST. So the project as defined under the RERA will be applicable even for the purpose of GST, and therefore if you have defined 3 towers as one project in RERA, you apply the same project principles under the GST law. If you have defined the second 2 projects or 2 towers as a project under RERA, apply same concept under the GST law and determine the applicability of GST, and therefore the alignment with RERA has actually streamlined lot of interpretational ambiguities which existed prior to this sort of a definition being borrowed. Third, and that's where one needs to be very careful about, that there are certain prescriptions under RERA which may not have a similar requirement under GST law. We have just narrated 2 or 3 of them here, but this is something we need to be also equally careful about. So which are these? Say for first example, no deposit or advance to be taken by promoter without first entering into agreement for sale. The RERA makes it very clear that you cannot receive more than 10% of a money without registering your project and without entering into agreement for sale. Now, no such prescription exists under the GST law. GST law says that as soon as you receive the consideration, your liability triggers. Whether you receive this as an advance, whether you received post agreement to sale, whether you have a different milestone defined, as soon as you receive this amount, you are required to pay GST. That is what the time of supply under the GST law. Whereas RERA says that you cannot receive 10% or above consideration without entering into agreement for sale. Now let's take a hypothetical scenario that a developer has actually received 30% of a consideration but still not entered into agreement for sale. What will happen? Will you pay GST on that or not? Answer has to be yes, because you can't argue that RERA, under RERA I cannot take more than 10%, therefore I will not pay GST on 30%, because whatever you receive you are required to pay GST under the GST law, and it is not completely aligned as per the RERA requirement. RERA may have different requirements. It may be considered as violation under the RERA law, but you are still required to effectively pay GST under the GST law, even if you receive this as an advance. Say for next is marketing and advertisement before registration. RERA does not allow you to promote the project without the being it registered under the RERA with the RERA authority. Now, can we apply the same principle under the GST? I am actually promoting and effectively making an advertisement for the project. That promotional cost which I incurred, I am paying GST on that. Can I not take a credit of that GST? Answer is yes. I can take a credit of GST, because for the purpose of GST law, it is only limited when is it the service is for the purpose of business. Answer is yes, you are entitled to take a credit, as long as not it is excluded under 17.5. It is not excluded under 17.5. So therefore, GST law does not have any of this provision that, oh, you are registered for RERA and thereafter you are incurring the cost, then only we will allow you a GST credit. But if you are not doing it before that, then we will not allow you a GST credit. GST law talks about simple. Is it in the course of business and for the purpose of business, we will allow you the ITC. If it is not, we will not allow you the ITC. When have you registered your project for RERA, it does not really matter. So the simple point that we wanted to make it here, that there are certain provisions which are restricted under the RERA but may not have a similar sort of a requirement under the GST law, or in fact vice versa also, where there are certain requirements under the GST law may not have a similar requirement under the RERA Act, and therefore we need to be careful about. And therefore, we of course have a question answer session, but I will conclude in last slide on 10 minutes now on this slide, where we'll go through some of the interesting scenarios, how there is an interplay between the RERA and the other provisions, and effectively look at it for various perspectives. First one, that there could be a scenario where GST is applicable, but RERA is not applicable. Very interesting scenarios which could come in here. So the first one is construction of a building for leasing. So when I'm constructing a building, and we have lot of all infrastructure developers in Maharashtra where their business is do a leasing activity. So they construct the building and lease that for the purpose of and leasing that to various customers and pay GST on that on leasing activity. Even in the case of construction, you effectively construct that GST is charged and not available to as a credit for leasing. You may not get registered as a RERA project at all. You are constructing a building of say 20-30 towers, all commercial offices, and you are in the business of leasing. You are not required to register under the RERA law at all, because you are not constructing for the purpose of sale. Therefore, does it mean that the GST provisions won't be applicable? No. GST continues to apply you as normally as it is applicable. Now, one peculiar position which comes up here, that am I considered then as a promoter? So let me take an example here, that I am buying a development rights to construct a building for a leasing purposes. What will happen? That I am not required to register under the RERA. Therefore, I am not a promoter for the purpose of RERA. But under the GST law, GST is payable under reverse charge mechanism by the promoter, who is effectively buying the development rights from any landlord or from anybody. And this is again a reverse charge mechanism, whether it is a residential or commercial activity. Now, what will happen in this sort of a cases? I think that's where I started with. You'll have to apply in a contextual way. And if you would have been constructing for the purpose of sale, you would have been considered as promoter. And therefore, in our view, that even in those cases, reverse charge mechanism will apply. And you as a promoter only we consider because you are buying the development rights for the purpose of construction and leasing, and you will be required to pay GST under reverse charge mechanism. And the landlord is not required to pay any GST. So very important one, where GST is applicable, but RERA provisions won't apply. Look at the second one, SRA rehab building. We all know there are so many projects which happen in Mumbai, typically in Maharashtra, where there is a slum rehabilitation happening. What will happen in those cases where there is a slum rehabilitation is happening, where you are effectively building a rehab building and giving it to the slum dwellers? You are not required to register that building under RERA, because you are not selling that to any third parties. You are not promoting that for any sale. You are constructing, you are giving that rehab building to your slum dwellers. You will generate some FSI on which you will build a free sale building. For that you will register under RERA, but not for the rehab building. Then what will happen? Whether GST will be applicable on sale of that rehab building? Answer is of course yes. That all the construction you will be liable to pay GST to your contractor, and when in turn you will hand it over the rehab building to the slum dwellers, will also be liable to GST, even though you are not registered under the RERA for the purpose of a rehab building. Very important. Therefore, there are some distinction. This is what I am trying to bring to your notice, that where the GST is applicable, but RERA may not be applicable in that context. Let's look at it the third scenario. Building constructed for sale post OC. So I'm constructing a building. I don't want to sell a single flat prior to OC. What will happen? I may not be required to be registered under the RERA, but at the same time, all the contractor who is constructing that building will charge me GST, and I will not be entitled to any credit because I am selling post OC, and therefore I will be still under the GST net. I will have to still take a registration as a business. I will have to still pay to the contractor GST, whatever services, transportation, lawyers, all those services which I am taking under reverse charge mechanism, I will have to still pay that GST. But for the purpose of RERA, I don't need to register that project if I don't intend to sell a single apartment prior to OC. That means I cannot be considered as RERA registered project, but still I will have to administer all the applicable GST provisions in that context. So these are the scenarios which are interestingly where GST is applicable, but RERA is not applicable. Look at it on the other side of it, where RERA applicable, but GST not applicable. Very again are some of the interesting scenarios that we have effectively drawn. First is sale of a developed land. Now this has become a most contentious issue today because the development of a plot, we had a recent AAR where it has said that activity of a sale of a developed plot shall not be same as a sale of a land, and but rendering of a service under clause construction of complex intended for sale to a buyer and is liable to GST. Very problematic position today because it is a sale of a developed land, and I'm developing a land. I am providing the infrastructure such as the road connectivity, the electricity, the lightings and whatnot, and the AR authorities have held that this is effectively a sale of not a simpliciter land as excluded under Schedule 3, and you will be required to pay GST on that transaction. But that, according to us, a very contentious issue. One can still say that it is primarily a sale of a land with along with the other infrastructure facilities, and you may apply the infrastructure facilities a different rate of provisions and whatnot, but you cannot say that the entire transaction is liable to GST. But for the purpose of RERA, even if the development of a land as a project you are doing, and as we have seen the apartment definition, as we have seen the immobile property definition, you will still be required to take a registration under the RERA, potentially a disputed area under the GST. You may be get excluded under the GST, but RERA you will have to register your entire project and keep on selling that, and that is how you will have to effectively adhere to a RERA requirements, but may or may not be a GST law as far as when you sell the developed plots. Apartments sold post OC. So once you are registered under the RERA for the purpose of a project, then whether you sell the apartment pre OC or post OC, RERA is applicable. Every apartment sold, you will have to administer as per the RERA provisions. Whereas under the GST law, apartment which are sold pre OC, no GST is applicable. Apartments sold post OC, no GST is applicable, and therefore one needs to really look at it in that context, that RERA will have to be still be applicable because that project is registered under the RERA Act, and therefore you'll have to administer all the RERA provisions, but GST may not be applicable on that transaction. And the last set of a transaction, which is revenue share arrangement under the JDA for land owner. And revenue share arrangement under the JDA for land owner, and this is another very interesting concept under the RERA. Land owner and a developer both are required to be registered as a promoter under the RERA Act. Okay, so landowner is also promoter and the developer is also promoter under the RERA Act, whereas under the GST law, when we have seen landowner promoter definition, it is only in a context of where there is an area share. If you are a pure revenue share arrangement, in terms of the definition under the GST law, you are not a landowner promoter. And now we have seen that in case of a pure revenue share transaction of a landowner, when you are effectively transferring development rights to a developer, you are not required to pay GST. Neither you are required to take any registration under the GST law. GST is required to be paid under reverse charge mechanism by the developer, and he will be required to comply with all the GST law applicable provisions. But you as a landowner who is only receiving revenue share from the developer, you are not required to comply with GST law because it is not applicable to you. GST is under reverse charge mechanism and primarily exempt on the sale of development rights. Whereas for the purpose of landowner, promoter, for the purpose of developer, he will have to comply with that. But under the RERA Act, you as a landowner promoter, whether it's a revenue share or area share, will be considered as a promoter of a project along with the developer, and you will also need to be registered under the RERA Act as a promoter. But therefore, RERA is applicable, but GST may not be applicable to your transactions that effectively that you are carrying out here. So there is lot of similarity, there is lot of interplay, and at the same time there is also a lot of dissimilarity in the provisions, or there is lot of independent applicability of the provisions of GST law and a RERA Act that one needs to carefully examine in this context. And we cannot just borrow this like this and apply to the GST law or apply GST law provisions to the RERA Act, and without having any in the context in which it has been said, you can't just apply. With that, I will end with one again husband-wife story, which is what important now again a Corona days, where husband and wife were having in a balcony a nice whiskey, and out of suddenly after 5 minutes silence, wife says, "I love you." So husband of course got surprised, and husband says, "What's happening? Are you speaking or it's a whiskey?" He said, "No, it's of course me, but I'm not telling you, I'm telling this whiskey." So effectively, in what context those "I love you" said, why this has been used, to whom it has been said, all of this you need to really understand before conclusion. Similarly, in this sort of a context, while there are similarity exists between the RERA law, similarity exists between the GST law, till you don't apply in the context in which these terms have been used, it is not possible for you to straight borrow and apply those principles. And therefore there is a lot of interplay between both the legislation, and one should be really careful in applying those in this context. I sincerely thank you, all of you, for patiently listening to me, with of course a lot of network issues and challenges, but thank you very much WARC once again for inviting me for this session.
Yes, sir. Rohit sir, thanks for the elaborate session. And there is no sorry from your part, sir, because technical difficulties are part of GST and we are living with it. And whenever there is a session of GST, we face this. Now, I request Jayesh Bhai to take on the question and answers. Are there any questions, Jayesh Bhai?
Yeah, sir. Yeah, sir. Basically,
Yeah.
two questions are there. Yeah, I'm sharing the screen. 1 second.
शेयर करो मैं
Rohit sir, you
Yeah.
can share your cap.
हाँ सर किया जाए सर ने सर इसको थोड़ा बड़ा करेंगे
मैं एक
One
मिनट
second.
थोड़ा मेरा स्टॉप स्क्रीन कर देता हूँ, मेरा है पहले।
Yeah.
How do I stop? Okay.
Yes, Jayesh sir.
Yeah, sorry, I can see the. Yeah.
Yeah. Can you see the screen, sir?
Yes, I can see the screen. Yes.
1 second.
So the first question
should I-
that we have.
Should I read?
No, I will read it. I will read it.
Okay, sir. Okay.
As term land is not defined in GST law, can we borrow the jurisprudence from various decisions of Honorable Supreme Court and also Section 3A of the Land Acquisition Act to mean land to subsume all the benefits arising out of land? And therefore, the elements like TDR, royalty on extraction of would also mean land exempt from GST law. I think while this is what logically one should be doing, but that is not what is intended. In fact, we can't just borrow the definitions from the other legislation like Land Acquisition Act or Bombay Land Revenue Code. Land should be interpreted in a common parlance, and land, which is common parlance terms, is only bare land. And therefore, when you buy the land, one can say that I also buy development rights, but you are actually savoring those when you sell the development rights and the land. And therefore, when you are selling standalone development rights, then you are not selling the land per se as in the common parlance. And therefore, while those other definitions may consider this as land, but may not be strictly applicable in the context of GST law. Coming to the second question, person A has obtained a land on a long-term lease from government undertaking, and A assigns the said lease promoter B for constructing commercial apartment with the said assignments to be considered as supply. If yes, whether it shall be taxed under forward charge or reverse charge. I think this has been clearly been already clarified. This would be not considered as again a land, unfortunately. There has been some exemption provided in the industrial development land when there is a granting of lease happens, such as MIDC and others. But if person A is supplying it to the other person B, which is not a governmental undertaking, then there is no exemption provided. Assignment of rights will also be liable to GST, and it is liable under forward charge and not a reverse charge in that sense. And therefore, one needs to be clearly looking at that. There is no such exemption being provided at this point in time. We are all the, on behalf of various real estate associations, we are in the phase of making a representation on both these issues, wherein first it should be excluded being a land, and secondly, for a long-term lease beyond 30 years, ideally there should not be any GST applicable. But till that
Yeah, Jayesh bhai,
amendment, unfortunately, we don't have any issues to, we can't take a position, it is not liable.
Jayesh bhai, any more questions?
I think these are the two questions which we received at 2 till 12 o'clock. And let me check if there is any answer.
Okay. Yeah. In between, Rohit sir, can I ask?
Please.
Yes, the long-term lease matter. Now the CIDCO has started sending notices to the persons who have got the land from CIDCO from 1st July 2017, and they are asking for 18% GST right from July. Last years they have issued notices. So many clients have come up that how a residential plot given by CIDCO will come under GST due to this issue,
So
what
I
you
think,
referred.
fortunately, Umesh bhai, for a CIDCO, there is some exemption also. Even if it is not a commercial, it is considered, we need to examine that exemption carefully. It is not qua the residential or commercial. It is a leasing of an immovable property. Leasing of an
Yes.
immovable property is a transaction in service today. And if it's a transaction in service, there is a GST applicable except if it is exempted. So one needs to examine exemption applicable to CIDCO. If there are some exemptions applicable in the context of CIDCO, because CIDCO is a governmental authority and they are doing this as part of their obligation under 243W. And that's where one needs to really look at it and try and find some exemption for the residential apartments. However, short of that coverage under exemption, there will be a GST payable. That's point number one. Point number two, that because it is I am individually buying and therefore how can on individual there is a GST payable, all those arguments may not be really hold good. those will hold good when you as an individual sell those, assign those rights to other person. Then you are selling those, assigning to other person, you are not doing in the course of business, and at that stage it may not be applicable. But when you have first time bought it from SIDCO, there is an exposure subject to their exemption, one needs to examine.
Yes. Few
Yeah.
questions have come up, sir.
Yes, sir. 3 more questions. One second. Just let me increase the. So is it visible or should I increase the font?
No, that's okay. That's okay. So first, whether supply under 7(1) under CGST Act presupposes satisfying one of the terms sale as per section Sale of Goods Act. If something is not sale as per Sale of Goods Act, can still be subjected to GST. See, answer is yes. It does not presupposes sale means as per the Sale of Goods Act, because as we have examined, that has a limited applicability in that context. Here, sale we will have to interpret in a common parlance, which is a transfer of title in goods. Is there a transfer of title in goods which is happening? That would be considered as a sale for the purpose of GST law. But also, I think, Ganesh, you need to examine that because the GST law supply has much wider concepts. It's not only sale, it also has a concepts like barter, exchange, transfer. That itself is a wider
Yes.
enough to cover
Done.
transaction under a
Okay.
supply, and that will also to be applicable in this case. So don't only restrict to a definition of Sale of Goods Act. One is supplies are wider enough, but in also the sale is something which we need to be carefully looking at it in the context of common parlance purposes. Then we have next question. If a house is allotted to a landowner under a joint development agreement after getting the OC, is that allotment subject to GST? Answer is yes. Look at it, joint development agreement you signed prior to getting the allotment. And please examine, when you sign a JDA, thereafter developer constructs the apartment and give it to you after that. And when you sign a JDA, you are transferring development rights upfront. So the developer is receiving consideration even for that house prior to OC. And therefore you are not excluded under Schedule 3, and you will be liable to GST even if the house is allotted after OC, but under the agreement which is entered prior to OC, which the development rights has already got transferred as a consideration to them. So GST will be applicable even on that. And last question, RERA registered developed plots whether sold after release order remains as such land. How GST can be invoked on such land as it is exempt in terms of, I think that's a great question, and that is how I already told that actually that is ideally should not be liable to GST. But the advanced ruling authority unfortunately taken a view that this is not a simplicity a sale of land. It is actually beyond a sale of land. It is also various infrastructure services that you are providing, and therefore there may be a GST which may be applicable. So I agree with you that GST should not be payable, but AR have been taking a negative view on those sort of transactions. Okay, Umesh, I think we addressed this.
Yes. Now the questions are over. I request Manish Gadia sir to please conclude the session and present vote of thanks. Over to you, Manish bhai. Unmute yourself. Unmute yourself, Manish bhai. Unmute.
No, we can't hear you.
We can't hear you, Manish bhai. Okay. Manish bhai is not being able to unmute himself. Some technical issues are there. So I will do the honor to present vote of thanks and conclude the session. As taken over by Rohit sir from the beginning, Rohit sir has taken us to the Sales of Goods Act, then to the Transfer of Property Act, then Land Acquisition Act also, then RERA, the most important session. So thanks, sir, for your uh, deep knowledge of all the acts and its interplay with GST. And we could not have found a most perfect person other than you. And from day one, whenever we requested you, you were very happy that these types of sessions should be there and it should happen. And WRC taken that. So thanks, sir, for taking out the time. And I hope all the participants must have enjoyed it a lot and noted down the interplays between the GST and RERA, because they are going to help us a lot in future. And I also thank Jayesh Thakkar, coordinator, Jinit Shah, who is not there, Sumit Junjunwala, coordinator for this session, Manish Gadia sir, regional council member, and at the last, the team of WRC technical persons who are handling behind this, Mishra ji. And with these words, I end these sessions. Thanks, Rohit sir.
Thank you, sir.
Thank you. Thank you, all of you. Thank you for the
Thank-
opportunity. Thank you. Thank you. Bye.